Dennis O'Rourke.
Mr Speaker, New Zealand First supports the work of the Law Commission and of the officials who worked for so long to modernise and improve New Zealand's system of judicature. It's a bill that's been a long time coming, and I think that overall New Zealand First has no difficulty with anything that it provides, except for one thing which I'll come to later. But I do want to pause just at this time to say, as others have, that there is one major glaring issue which the bill doesn't cover and is outside its scope, but nevertheless I think just a few seconds to reiterate that the really big issue for the justice system in New Zealand is the cost of it, and therefore the access to the system by ordinary people who simply so often can't afford to pay for justice. And we've all had people in our offices talking to us about that, and most of us have tried to help people through the system only to realise that the cost is the real barrier. And therefore, what I have often asked this government to do, I ask them to do once again, to have another look at the legal aid legislation, to improve the thresholds so that a far wider section of the New Zealand community can have access to legal aid. Because in the end, that is the only way that we're going to tackle that major problem of the cost and therefore of justice and therefore access to it. Now, Mr Speaker, New Zealand First will not be voting in favour of this bill, not because we don't support most of what it says at all, but only for one reason, and that is the requirement for the compulsory retirement of judges at the age of 70. That for us is a deal breaker. That means we cannot vote for the bill, even though we support 99% of the rest of it. Now, the reasons why we think this is so important are firstly that this is just plain simple ageism. The government should be ensuring that people capable of working beyond the age of 70 are given, as of right, the opportunity to do so. The Human Rights Act itself is very clear that age as a means of discrimination is unlawful. Employers can't do it. Why should the state be doing it when it comes to judges? Thirdly, it is utterly unnecessary for there to be a requirement for retirement at age 70. Few people who find themselves unable to perform their duties after that age, or even before it for that matter, would wish to continue to do so, and there's no reason why the Chief Justice should not intervene and talk to people who were in a position where they should be retiring. But the real reason is this, Mr Speaker, that age 70 is not so late in life these days that very able people shouldn't be able to continue to carry on. And I've appeared before judges well over the age of 70 who were very, very astute indeed. And in fact, their experience should not be taken lightly, because that experience is of huge value for the Judicial Commission and the community. And Mr Speaker, if there really are issues about the competency of judges, then they arise at all ages. There's nothing magic about the age of 70 to determine whether somebody suddenly becomes not competent or not. So if there really is an issue about competency, then why aren't judges on a 7-year appointment basis? Renewable for those whose appointments should be renewed, and not renewed for those whose appointments should not be. So that would be a far better and fairer and more effective system than this arbitrary choice of age of 70. We're voting against it for the bill for that reason alone. But I also want to place on record New Zealand First's strong objection to the failure of the government to legislate now for the publication of all district court judgments. And we don't mean those minor pronouncements that are made orally, but fundamentally all district court judgments. Now, we were told that the reason why the bill no longer requires that publication is resourcing issues. And yet we were told this, and I quote, by the officials, and I quote, "The Chief District Court Judge is advancing work to enable significant District Court decisions to be published, and the Ministry is working closely with her to establish this publishing capacity from next year." So this is imminent. Obviously, there are resources being made available, and I don't see why the legislation shouldn't now provide for the publication of those judgments, even if there is to be a delay before it is actually done. As far as I'm concerned, this government is simply reneging on its responsibility and its undertaking, in fact, originally, to see that the District Court judges were going to be published. And the bill itself sets out to say that one of its most important purposes is the transparency of the judicial system. And that comes right down to the publication of judgments through all of the court system. So it's very strange that a bill that sets out to be transparent is actually now not providing for transparency as far as District Court judgments are concerned. And remember, the District Court now has jurisdiction of up to $300,000. So that's by itself one good reason why those judgments need to be published. And what we saw in the original legislation was this, and I think it should have been retained. And I quote, "Every final written judgment of the court, excluding family court, youth court and a disputes tribunal, must be published on the internet as soon as practicable unless there is good reason not to publish the complete judgment." And then it goes on to say, "Final written judgment means a written decision that determines or substantially determines the outcome of any proceedings and is either a written reserved judgment or B, an oral judgment transcribed by an official transcription service." Why on earth are we not seeing that preserved in this bill? Of course it should be. The argument for resourcing is a vacuous one. We can see from the officials' own advice that resources are being made available, that it will be possible to publish District Court judgments next year, at least the significant ones. It's a small step further for the legislation to provide for the publication of all such judgments, with the exception of those which it's simply unnecessary to provide for. So, Mr. Speaker, New Zealand First would not have voted against the bill because of the failure to require publication of District Court judgments, but we cannot vote for a bill with such an objectionable provision in it as to require the compulsory retirement for judges at the age of 70 years. And that's a disappointment to us, because we think that this is otherwise a very good piece of legislation which we would have preferred to support. But that provision is so objectionable that it means we have no choice but to vote against it. And for that reason only, you will hear, Mr. Speaker, our vote against the bill for that reason. Otherwise, I do want to make it clear that New Zealand First does support the work that's been done by the Law Commission and by the officials to bring forward legislation which will update and improve New Zealand's judicial system in the way that is proposed in the bill. So I'm sorry to those who will be looking forward to our vote for the bill, unfortunately, because of the provision for compulsory retirement of judges at age 70, our vote has to be against.
I call